So good day everyone. Today we will talk about the 1987 Constitution of the Republic of the Philippines, Article 7, the Executive Department. So as a sort of review, we know that our government is divided into three branches, namely the legislative, executive, and the judiciary. So this separation of power is an attempt to prevent the concentration of power in the hands of a single group of people or a single individual. So in such system, the executive does not pass the law, which is the role of the legislator, nor interpret the law, which is the role also of the judiciary. Instead, the executive enforces the law which are written by the legislator and interpreted by the judiciary. So in this topic, we will know the nature of executive power, the composition of the Philippine executive, qualifications, duties, and powers of the members of the executive branch. So now let's go to Section 1 of Article 7 in the 1987 Constitution. So it states that the executive power shall be vested in the President of the Philippines. So what is executive power? So, executive power has been defined as the power to administer the laws. So, that means that it is the president being the highest official that has the power to enforce and to administer the law. So, he is the head of the government, the head of the state, and also the commander-in-chief of the armed forces of the Philippines. Also, the president has the control to all the executive departments, bureaus, and offices of the country. So he has the authority, but of course it is coupled with the responsibility to see to it that the laws are faithfully executed. So that is the function of the executive department in the concept of what executive power is. So now let's proceed to the composition of the executive department in both national and local level. In national level, we have the president, the vice president, and the cabinet. So, the cabinet entails the alter ego of the president in the respective department. So, in the Philippines, we have a lot of departments, executive departments, the DepEd, the DAR, the DTI, the DOLI, and a lot more. So, these departments having executive secretaries, so that compose the cabinet. So, those executive secretaries coming from different departments are the member of the cabinet. Now let's proceed to the local chief executives. So the governor is the local chief executive in the province. The city or municipal mayor is the local chief executive in a city or in a municipality. And a barangay captain, it is the local chief executive in the barangay level. And now let's proceed to the qualifications of the president. So under section 2, it states that no person may be elected president unless he is a natural-born citizen of the Philippines. He is a registered voter. He is able to read and write. He is at least 40 years of age on the day of the election. And he is a resident of the Philippines for at least 10 years immediately preceding such election. So as for the qualifications of the vice president, so the vice president must have the same qualifications as the president, and that is stated under section 3 of the article 7. So the constitution does not prescribe any educational, academic, or literacy qualification except only the ability to read and write, but not necessarily in English. So that is in line with the egalitarian objectives of our democratic society. So there's no need for you to get any college degree just to qualify in the position.
Election of the President and the Vice President. System of direct voting. System of popular election. So, what is direct voting? Direct voting in which the people vote directly to the person or a political parties in which they want to see or to be elected in the position. Election by Congress in case of a tie. So, in this case, it will happen. So, the majority of the votes of Congress in the session will be a symbol. So, they will gather together so that the Congress will be the one to vote who is or who will be the best for that position, or vote the right person for that position. The Vice President is elected with and the same manner as the President, of course, because the President and the Vice President have the same qualification in terms of office, and that will be elected in the same manner as the President. That's why, what is the qualification of the President? Same as also as the Vice President. Term of the Vice President. The President and Vice President enjoy security of tenure. The term of office is 6 years, which shall begin at the noon on the 13th day of June, following in the day of the election, and shall end at the noon of the same date, 6 years thereafter. So, one term worth of 6 years, starting and ending of the noon of the June. So, every June 30, like for example, our former President Rodrigo Roa Duterte, June 30, 2016. So, by June 30, 2022, she will end her term for office of the President. Re-election of President and Vice President. The President is not eligible for any re-election, but they may be elected to be in a lower position. Yes, the President has only one term worth of 6 years, because 6 years is enough for a one term of a President sitting in the position. 6 years is long and it is enough for a good leader to handle or manage the country. In the case of Vice President, he or she cannot serve for at least 2 or more successive terms, but he or she eligible for election as a president.
Classes of presidential succession. Before assumption of office by the president-elect at the time fixed for the beginning of his term, and after assumption of office by the president-elect at the time fixed for the beginning of his term. When the vice president shall act as president, if the president-elect fails to qualify, or if a president shall not have been chosen, or in case of temporary inability or incapacity of the president to discharge his power and duties. The vice president-elect shall act as president until the president-elect shall have qualified, or a president shall have been chosen and qualified, or the disability shall have terminated. When vice president shall become president. If the beginning of the term of the president-elect shall have died or shall have become permanently disabled, or after assumption of the office, in the case of death, permanently disability, removal from office, or resignation of the president, in which case the vice president shall serve the unexpired term. In case of the removal of the president from office, of this death, of resignation, the vice president shall become president. Where there are no president and vice president. Before assumption, the Senate President, or in case of his inability, the Speaker of the House of Representatives shall act as President, until the President or Vice President shall have been chosen and qualified. After assumption, the Senate President, or in case of his inability, the Speaker of the House of Representatives shall act as President in case of death, permanently disabled, removal from office, or resignation of both President and Vice President, until President and Vice President have been elected and qualified. where Senate President and the Speaker are also enabled to act as President. Congress is mandated to provide by law for the case when both of Senate President and the Speaker of the House of Representatives are also unable to act as President, or for the case of death, permanent disability, or resignation of the acting President, including for the manner of his selection, until the President or Vice President shall have been elected or qualified. Vacancy in the office of the Vice President, in case a permanent vacancy occur in office of the Vice President during the term of which he was elected. The President shall nominate a Vice President from among the members of the Senate and the House of Representatives. The nomination this subject is confirmation by a majority vote of both houses of Congress voting separately. The nominee shall assume office upon such confirmation. Vacancy in the office of both the President and Vice President. Special election. The Congress shall convene and enact a law calling of a special election to elect a President and Vice President. The next presidential election. No special election shall be called if the vacancy occur within 18 months before the date of the next presidential election.
Roles in case of temporary disability of the President. Declaration by the President. The President may transmit to the Senate President and Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office. This declaration of the President, it is understood that the President is unable to do of the part of his duties and responsibilities. It is understood that the President is needed by the help of the power of Senate President and Speaker of the House of Representatives. They can have a right also to save the obligations of the President temporarily. Declaration by members of the Cabinet. In case a majority of all members of the Cabinet transmit such a written declaration, the Vice President shall immediately assume the powers and duties of the office as acting President. So, what is the roles of members of the Cabinet? The roles of members of the Cabinet is to advise the President on any subject he or she may require relating to the duties of each member's respective office. If the President unofficially offline of his duties, the Cabinet members can transmit of the Vice President as acting a President. But in the chart, show us a Vice President assume the powers and duties of the office as acting President. Decision by Congress in case of a dispute. In case of a dispute between the majority of all the members of the Cabinet and the President, Congress by a 2 or 3 vote of both houses, voting separately shall decide on the existence and or termination of presidential incapacity. Prohibitions during their tenure. They shall not hold any other office or employment unless otherwise provided in the Constitution. They shall not practice any other profession. They shall not participate directly or indirectly in any business. They shall not be financially interested in any contract or franchise. They shall strictly avoid conflict of interest. Purpose of prohibitions: to ensure that the officials mentioned, particularly the President, will devote their full time and attention to their duties. So, purpose of prohibitions is to remind the President and officially members of the office to do their duties. Other officials are to similar prohibitions. Similar restrictions apply to the members of Congress and of the Constitutional Commissions and the Tanal Bayan and his deputies. They seek to stress the principle that the public office public trust. Um, Other officials are to similar prohibitions belong Tanalbayan, Congress, Constitutional Commissions, and his deputies. They can help society and our country.
Nature of power to appoint. The power of appointment is intrinsi- intrinsically an executive prerogative. The leg- legislative the legislative has nothing to do with designating the man to fill an office. The executive nature of appointing power does not imply that no appointment by Congress and the courts can be made.
Officials whose appointments are vested in the President under Section 16. So the President elected the heads of executive departments, ambassadors, and other public ministers and consuls, officers from the armed forces of the Philippines from the rank of colonel to naval captain, other officers whose appointments are vested in the President by the Constitution, all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint, such as the head of the government-owned or controlled corporations, department undersecretaries, heads of bureaus and offices, and other officials. Under other provisions, the President, under the provision of the Constitution, appoints the members of the Supreme Court and judges of lower courts, including the Sandigan Bayan, the regular members of the Judicial and Bar Council, the chairman and the commissioners of the CSC, COMELEC, COA, and the Ombudsman and his deputies.
Of presidential appointments. Regular appointments, those made during the session of Congress. Ad interim appointments made during a recess of Congress.
Removal power of the President. Extent of the President's power to remove. With respect to constitutionally officers, removal only by the means of impeachment and judges of the lower courts. With respect to civil service officers, the Constitution does not say how appointed officers should be removed. Some politicians want Senate approval to removes as well as the appointment. Other argues that the President must have the power to remove incompetent appointees. The power of control over all executive departments, bureaus, and officers. The rule of the President as administrator. As administrative head, the duty of the President is to see to it that every department, bureau, and office under the executive branch is managed and maintained properly by the person in charge of it in accordance with pertinent laws and regulations. Until a law is declared unconstitutionally, the President has a duty to exemplify it regardless of his doubts and to its validity. Power giving control. These are the two factors that contribute to the effective hold and control of the President over all the executive departments, bureaus, and officers. First is the power of appointment, to make the other person the outright owner of the property left by the decedent. Second is the power of removal, remove officials. Exemption, those appointed by him where the Constitution prescribes certain methods for separation from public service. Power to ensure that the laws be faithfully executed. The President to take care clause modifies that grant requiring the President to take care that the laws be faithfully executed. At the founding, the President approves over law execution was praised and ensuring prompt and vigorous implementation of laws. More of the mandatory duty than a power. The functions of the President to see that the laws are faithfully executed is more of a duty than a power.
Military power of the President. A president has the powers to meet emergency situation. He has the powers to call out the armed forces to prevent or suppress lawless violence, meet the threat of invasion, or quell rebellion. The President has the powers to suspend the privilege of the writ of the habeas corpus and to declare a martial law. Commander-in-Chief of Armed Forces. A President is authorized whenever it becomes necessary to call out such armed forces to prevent or suppress lawless violence, meet the threat of invasion, or quell rebellion. Power to suspend privilege of writ habeas corpus. So habeas corpus, it is a writ requiring a persons under arrest to be brought before a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. There are two conditions that are necessary in order that the President may suspend the privilege of the writ. First, there must be an invasion or rebellion. Second, the public safety must require the suspension. In case of these two conditions, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law. Meaning of martial law. So first, in its comprehensive sense, it includes all the laws that have reference to and are administered by the military forces of the state. They include the military law proper, and then the rules governing the conduct of military forces in times of wars and in places under military occupation. Another meaning of martial law. In its strict sense, it is a law which has application when the military arm does not supersede civil authority, but is called upon aid in execution of its vital function. The Constitution refers to this meaning of martial law, means that the state or part of the country is under military control. Power to declare a martial law. The power to proclaim martial law includes the power to make all the needful rules and regulations with the force of law until the termination of martial law. The President may place under martial law the whole country or only part thereof. He has the control whether he will put the whole country into martial law. This power to declare a martial law is resorted to only when the emergency situation requires taking of the stronger measures of ensuring the safety of the nation. Effects of martial law to operation of the Constitution. It does not suspend the operation of the Constitution. The declaration does not mean the military authorities will take reign of the government. Functions of the civil courts and legislative assemblies. It does not supplant the functioning of the civil courts or legislative assemblies. Martial law is declared merely to assist the civil government, not supplant it. Jurisdiction of military courts and agencies. Under martial law, for instances, a person may not be arrested and detained indefinitely without court's orders. When martial law is declared, civil authorities are not suspended by military authorities. Privilege of the writ of habeas corpus. It does not automatically suspend the privilege of the writ of habeas corpus. During the suspension of the writ, it shall apply only to persons judicially charged for rebellion or offenses inherent or directly connected with invasion. Even a person is arrested or detained, he shall be judicially charged within 3 days, otherwise he shall be released.
Pardoning power. Meaning of the pardon has been defined as an act of grace proceeding from the power entrusted with the execution of laws or precedent, which exempt the individual on whom it is bestowed from the punishment the law inflicts for the crime he has committed. So, pardon is release from guilt or remission of punishment. Pardoning power. This power cannot be taken away from him nor can be exercised thereof be subject to limitation or condition beyond those provided by the Constitution. Neither way, the courts inquire into the wisdom or reasonabilities of any pardon granted by the President. The other one is, his discretion is absolute. The last one, the pardoning power extends to all offenses including criminal contempt. It does not give the President the power to exempt except from the punishment anyone from the law. There are two kinds of pardon, absolute and conditional pardon. Absolute when it is not subject to any condition whatsoever, it becomes effective when we made it, and conditional when it is given subject to any condition or qualification the President may see fit. It must be accepted by the offender to become effective. Difference the two. Absolute pardon, it is convict granted, sentence was entirely remitted, whereas conditional pardon, the convicts was free as long as they remained in the colony. Authority to contract and guarantee foreign loans. Exclusive executive function. The President may contract foreign loans on behalf of the Republic of the Philippines without the need of prior congressional approval. This is possibly the official better qualified to enter into such negotiation than the President. Concurrence of the Notary Board required. The authority of the President is not absolute. The contract of guarantee must be with the prior concurrence of the Notary Board of the Central Bank, now Bangko Sentral ng Pilipinas, which is required to make a report to Congress containing the matters of mention. Check by Congress. Reason. The loans urgently needed by the country may no longer be available when concurrence, which is usually takes some time, is finally obtained. Other one. An obstructionist Congress could withhold approval for political reasons. However, as a check of executive power, Congress may, by law, place limitation on its exercise and make the necessary investigation in aid of legislation if it is believed that the borrowing based on the Monetary Board report is not justified. Budgetary power of the President. The President is trusted by the Constitution with the task of preparing the budget of receipts and expenditures based on exciting and proposed revenue measures and other source of financing, and it is submitting in the Congress within 30 days from the opening of each regular session.